Hey everybody, welcome to Active Self-Protection Extra today here on John's Briefs with Terry Johnson, expert criminal defense attorney in the state of Michigan and also the star of firearms legal protection.
I don't know about a star.
You're the star.
No, just maybe a fading star.
But Terry is here with me in the 338 Club at C2. And today I want to talk about, as a defendant, when we are defending ourselves from the fight after the fight, if we really want to think and whether we should testify in our own defense.
Now more than ever, you need trusted coverage to help you win the fight after the fight. The company I trust and recommend is Firearms Legal Protection. They offer discounts on all their plans at the link in the description. I recommend the premium plan.
So Terry, I'm going to set this question up for you and then let you run with it.
And just so everybody's aware, I did not know we're going to talk about this till he just said this about 15 seconds ago.
Here's the way I always do these videos.
I love it.
I feel like if we script things out, they just don't. It's not as good a discussion.
Right.
But if instead I go, Terry, tell me about this thing and what you think, then now we're just having a discussion.
Exactly.
And I find those impromptu discussions are more valuable for education. So let's set this up, this idea of testifying in your own defense. Now, if you were a part of last month's, or I guess it might be a month and a half ago now by the time this posts, seminar that we did on reasonableness. And the big reasonableness was a 4-part test.
Right.
There was a subjective and an objective belief of fear, right, of death or great bodily harm, and again a subjective belief in that fear,
right,
and the objective reasonableness of that belief, and then the subjective belief in the need to use force or deadly force, and the objective reasonableness of that belief, right? So there's these two here that say, did you actually believe this thing, and did you actually believe this other thing?
Right.
And so given those, it would seem that the only way to establish those is by the mouth of the defendant. But what are your thoughts?
Okay.
Right, here it is, ready? It depends.
Let's start with this. If I can get everything in without my client taking the stand, I'd prefer to do that.
Because then he doesn't have to be cross-examined.
Doesn't have to be cross-examined. He or she is, they won't make a mistake up there. I mean, I've done trials, I've prepped witnesses, and I had one that got on the stand and told me a story I never heard before.
Never heard before.
In a self-defense, and I'm just like, and the person said to me, well, I just remembered it once you asked me that question that time.
Oh.
And that's
not a good thing. That's a bad day.
It was not a good day. But here's the other part about this. If you get in a situation where you've had to use self-defense and you assert self-defense, you have to take the stand. You have to take the stand and say, I was defending myself, or let your attorney make the elements of self-defense. You just don't get to say, this is self-defense and walk away.
Right. So it's an affirmative defense.
Yes, and in order to do that, you have to take the stand. Now, let me give you a couple of other things to think about. Where are you when this is going on? Let's say you're in a position where...
Hold on a sec, Terry. I want to tell for anybody who doesn't understand that, an affirmative defense means I affirm, I did the thing. But the reason
I was justified.
But I was justified in why I did the thing.
Yes.
So I'm stipulating to the action. I'm saying, yeah, I killed that guy. But I did so with justification.
Absolutely.
And therefore I have to explain those two subjective things.
Click on the link for law school for John Curry. We're going to get him there.
It's not happening. All the other stuff, like if I could just be Perry Mason and go into the courtroom and do this, I'd do it. But it's all the other stuff.
It's a lot of stuff. It's a lot of stuff.
I want to make YouTube videos.
But let's go back to this though. Seriously, you're right. It is an affirmative defense. You have to stand up and you have to say, yes, I did X, Y, and Z. Now, here's the downside of this. Where are you? And what do I mean by that? Where are you spending your time? Let's say you can afford an attorney, but you can't afford bond. So you're in jail at this point.
You're going to spend all that time in jail.
And why is that important? Because you're not going to get the level of sleep and preparation that you would, let's say, if you were at home. Now, if you've got, if you can afford both, or you have a plan like Firearms Legal, where we take care of your attorney's fees and your bond and things along those lines, you can, be out and assist your attorney. But where are you? If you're locked up in jail that's going to be a lot harder for you.
Big time.
You're not getting the sleep. And again, how long have you been there? It's not going to be days. It's probably going to be months. And in some jurisdictions, it might even be years, believe it or not, if you live in a jurisdiction that doesn't have a speedy trial rule. And just so you know what that means is, in Michigan, you've got to go from point A, from when the event happened, to trial in about 180 days.
So that's considered speedy, 6 months.
Correct, and that's if you're incarcerated. Okay, if you're not incarcerated, it's not a big deal. But if you're incarcerated, it's about 180 days. If some states, in the South especially, don't have a speedy trial rule, so you might be in jail for literally a couple of years waiting on your trial to come.
And obviously then you're not making any money, you're not loving your family. Those are a big deal.
Correct. Now, has that weighed on you? It's very possible it could. But
no, it's impossible that it couldn't.
yeah, and here's the other thing. You get on the stand, you don't get to tell a story. This is what I tell all of my clients. You don't get to tell a story. You don't get to stand up and say, listen, this happened at 6 in the morning and I heard a noise and I was getting coffee and I normally do this. You've got to answer questions, and then, like you said earlier, you've got to handle cross-examination.
Now that means you have a prosecuting attorney who is a professional at this. That is their whole life. That in these, especially, well, I mean, I guess in a real small county or something, maybe not, but here in Phoenix, I mean, they're prosecuting attorneys. That's their whole life is trial.
Yeah.
That's all they do. So they are a pro at it, and you are an amateur at being cross-examined.
And let me tell you, I was on the stand one time out in California, and generally a good attorney is about 2 to 3 questions ahead.
Charged with vagrancy? Is that what you're facing there?
It was thrown out. I don't want to talk about it. No, but all seriousness, I was involved in a civil trial out there, and realistically, a good attorney is 2 to 3 questions ahead of you.
Right.
Very good attorneys are probably 5 to 6 questions ahead of you.
Playing chess.
And I had this attorney ask me a question, and I answered it. And when he asked the question, I said, "Okay, checkmate. I know where he's going with this." And question 2 was this, question 3 was this, question 4 was this, and checkmate in 5. I knew exactly where he was going. Most people can't think that far ahead.
That's an awful lot to ask.
And here's the other thing. You don't, like I said, not only do you not get to tell your story, sometimes your personality may come out in a way that you don't want it to. And what do I mean about that?
Some people are abrasive.
Yeah, but they're lovable people, but they don't come across well to a jury. You put everything, your personality, even though we talked in other videos about we want to take all of the bias and things out and just let the facts apply. Unfortunately, we're all human, and we're going to look at someone and say, that guy reminds me of my ex-husband. I hate him. He acted like my brother, and my brother was this. Or somebody may say, you know what? This guy reminds me of my son. I'm going to believe him. And you never know. You never know.
Those snap decisions on whether I like somebody or not, whether they're trustworthy or not, is a real thing. And you might go, but I'm trustworthy. Okay, but do you come off that way? Do you, do those things? Which I think that the payoff here is, so if you're going to make a self-defense claim, you're going to have to take the stand. Because it's an affirmative defense.
Exactly.
Which means you're going to need a lot of time with your attorney to prepare that defense.
And make sure, again, your viewers know to get a good attorney. And what do I mean by that? You want somebody that's skilled in trial, that's skilled in criminal trials. Having a bankruptcy attorney or a divorce attorney,
it's not going to help you.
It's not going to help you, and you don't want to put your lives in that person's hands.
Well, and you're going to need time and an ability to be prepared. So you're going to give depositions. You're going to then.
The very few jurisdictions do depositions as it relates to criminal.
As criminal, okay. So civil trials.
So the thing you really want to keep in mind is, the first time anyone's going to hear from you will be when you are on the stand.
Wow. But your attorney's got to prepare you for cross.
Oh, absolutely.
So you're going to be spending hours and hours and hours and hours with your attorney going, hey, this is the direction we think that this prosecutor is going to go. So we got to put you on through mock trial so that when you talk to this, when they ask you questions, You know how to, so I remember the only time I've ever been deposed, right? And my attorney looked at me and said, you will answer the question and you will shut your mouth.
That's right.
And literally several times he kicked me under the table and said, I believe you've answered the question.
Yeah.
To keep me from continuing to talk. And very difficult because, as you guys know from watching this channel, I like to talk.
And that's the key. Most people like to talk, especially when you're in a situation where you want to defend yourself.
Yeah, I want to explain myself.
Yeah, and there are times I just want a yes or no answer. You know, were you here on this date? Well, the reason I was there, that wasn't my question.
Yes,
were you here? Yes. And it's, if you learn, you know, not learn, but your attorney should take you through those types of things. I was here, yes, I didn't do this, yes, and let your attorney come back and fix it on the other side.
Right. And here's my plug. This is why I'm saying this, okay? Is that every hour you spend with your attorney preparing for this trial are billable hours. And not just billable for your attorney, billable for the paralegal that's there, billable for the other attorneys who are in the room, for the expert witnesses who are hopefully part of your holistic defense.
Yeah.
Talk through this. This stuff adds up in a crazy hurry, you guys. I mean, a self-defense encounter that gets to trial, you're talking $100,000 is a bare minimum. $250,000 is real reasonable, and it can go up. So that's why I'm a member of Firearms Legal Protection, and that's why we've partnered with you guys so much, because at the very least, all the time I'm going to invest, all the heartache, the lost sleep, the stuff in the news, that's all coming my way. To not have the financial hardships on that as well, I think is really important.
Well, and here's the other part of that. You know, you're going to get a vetted, skilled criminal defense attorney. You're not going to get somebody that only does dog bites and this is their first trial. We don't want our attorneys practicing on you. That's not what you're paying us to do.
So what we're going to talk about next week here on John's Briefs is I'm gonna shill just a skosh, because we're going to talk with the expert from Firearms Legal Protection about whether you get to pick your own attorney or they get to pick your attorney and why that's important. Terry, thanks for the information.
Thank you.